Welcome to the chapter 15 presentation covering seller and buyer remedies under the UCC. So let's get started. We're going to be focusing on Part 7, which we're actually going to call Chapter 7 because we're in the Texas statute of Article 2 of the UCC. As you probably recall, Article 2 is really the only part of the UCC that we're kind of playing around with in this particular course. There's lots of other parts. I think there might be a total of 11. Don't quote me on that, but something like 11. But we're just going to be thinking about Article 2, and we're going to be focusing upon Section 7 here. And this is the section that tells us what a successful seller who sues, or excuse me, a plaintiff who is the seller and is successful in the lawsuit is likely to recover. And we're also going to discuss the situation in which the buyer is the plaintiff and is successful. What is the buyer going to be able to recover? So let's get started on this fascinating topic. Okay, so we're going to first of all focus on the seller. And we're going to go through the common or the most frequent remedies for the seller. I'm going to correlate them to the statute, the Texas statute that we deal with. One of the things that I kind of find interesting about this is that while we're going to talk about these different types of remedies, you might think, well, gosh, this probably has pages and pages of information in the statute, when in fact these are very, very short little sections in the statute. So we're going to talk about them and pretty much exhaust the material about what you can comment on. So let's consider the situation of the seller who's suing the buyer. This may have arisen because the buyer has breached, the buyer has refused to pay, or perhaps the buyer is unable to pay. The buyer wants to pay, but just doesn't have the resources. And so the plaintiff seller has several different choices. And you can see here I've labeled some of the more common ones. So we have 1, 2, 3, 4. And we're going to go on to talk about 5, 6, 7. We're going to talk about 7 of the common ones. And I have flagged where we would find these in the Texas statute. Let me go through them briefly and then go back and relate them to the Texas statute. One thing that the seller can do is just not deliver the things to the buyer. This oftentimes happens when the buyer doesn't have the money, and the seller knows that the buyer doesn't have the money. So why continue to fulfill orders for the buyer, even if you have a contract, when you know you aren't going to get paid? This is, in a way, a type of self-help. I mean, in these circumstances, the seller doesn't actually have to sue the buyer to recover this. The seller just says, wait a second, I've had enough of this. This is not working for me. I'm not going to deliver anything more. Another option, which is a little bit less severe, is to just say, listen, buddy, I want to honor my contract with you, but I don't think you're going to pay me. And so you need to pay me on delivery. You need to pay me cash, COD. If you don't have cash, there is not going to be a delivery. The UPS man is going to take that stuff away from you. Sometimes the seller's going to hear about the insolvency or the breach after the goods have left his control and are in transit on the common carrier. Sometimes it's possible for the seller to pull those items back and tell the common carrier, don't deliver those items. In that situation, we call that stoppage in transit. And here's the definition of stoppage in transit. It's a right of a seller of goods on credit. And so here the seller hasn't actually been paid the money. He's expecting to be paid, and he's thinking he's not going to be paid after all. So it's the right of a seller of goods on credit to retake them while they are in the possession of a carrier or other intermediary upon discovering that and this should be buyer here. I've left off the word, I apologize. And then finally, if he somehow or another gets the items back or never surrenders the items to begin with, so any of these 3 scenarios, he says, well, now that I've got this stuff, that's good. It's a good first step in solving my problem, but I'm in the business of selling this stuff. I don't particularly just want to accumulate it. Well, now he's going to need to go ahead and sell the items to somebody. Now, very likely he's not going to be able to get his normal purchase price, especially if these goods are in some sense not fungible. And so he may have to be satisfied with, 90 cents on the dollar or 80 cents on the dollar or something like that. Let's imagine for a second that the purchase price of these items, or that the buyer had agreed to buy these items. I'm not quite sure why this isn't working. Let's go ahead and try and see if I can get this to work. Here we go. So let's say that the buyer had agreed to pay $10,000 for whatever is being delivered. And so the seller had manufactured these items according to the specifications that the buyer had created. But after the items are manufactured, the seller figures out, hey, the buyer's not going to be able to pay for these items. So the seller either doesn't deliver them, or um, uh, attempts to deliver them COD, or whatever. Anyway, so the buyer doesn't pay for them, so the seller has the items back. The seller is going to try to sell those items to somebody else, and the seller, is required to try to get as good a price as he can. It may be that the seller can get the whole $10,000, which is awesome. It's even possible, I suppose, that he could get more than $10,000. But more often than not, he's going to get some amount less. I mean, depending upon exactly what the item is, it might be $9,000, it might be $900, especially say if the items are highly customized and the average person doesn't want them. You have to tie the circumstances. So how does a seller go about selling these items? Well, he has to do so in a commercially reasonable manner. So for example, if I am selling widgets, let's say I have a big widget factory and I'm selling the widgets that I wasn't able to get the buyer to take or to pay for, there might be outlets or customers that I would ordinarily expect might be in the market for widgets. Or there might be intermediaries I could sell it to who are entities that regularly sell widgets in the general marketplace. Those would be places that I ought to look. I probably shouldn't just put up a small sign off of the loading dock of my facility and say, hey, if you want a widget, come and see me, or something like that. I need to do it in a way that's likely to cause people who would be interested in these items and who could afford to pay for them to be aware that I am trying to sell them. Now, what is commercially reasonable is going to vary depending upon what the item is, what the industry is, and how long these items are good for, all of those issues. And so that becomes a factual issue whether I've done it in a commercially reasonable manner or not. Let's assume that our initial purchase price was $10,000, and let's say I'm able to sell them in a commercially reasonable manner for $9,000. So the difference obviously is $1,000. That is what I'd sue for. That's the difference. This idea here is a form of mitigation. This is a duty that all plaintiffs have. It's just fundamental to our legal system. So it's nothing unique to the UCC. Simply put, what this is the duty of the plaintiff to minimize his damages. Now, you might think to yourself, why would the plaintiff want to do that? I mean, the plaintiff wants to get as much money as he can out of the lawsuit. That's just human nature, to maximize your profit, right? Well, understandable that the plaintiff would want to do that, but the law says that the plaintiff's job is really to keep the damages as low as possible. And the way that the court system enforces that or motivates the plaintiff to do that is the court will say, listen, buddy, listen, plaintiff, if you win, you're just going to be able to get if you had mitigated your damages, what you would have been entitled for. So let's say, going back to our example, let's say that the facts were a little bit different. Let's say that in our case, the original purchase price was $10,000. Our plaintiff sold the items not for $10,000, but for $2,000. Then turns around and sues the buyer for the difference, $8,000. Maybe the buyer says, you're right. I messed up. I should have taken the delivery. I should have paid you the $10,000. I can see that I'm liable. But you should have been able to get a heck of a lot more money off of those widgets than $2,000. And in fact, I'll show you, I will present evidence that you could have gotten as much as $9,000 for those. Let's assume that he has powerful evidence about that. He presents witnesses who'd say, yeah, I would have bought those widgets for $9,000 at that particular time if I had been aware that they were for sale. So if the buyer was able to present it and persuade the jury of that fact, the jury would say, we're not going to look at this 2,000 number because that wasn't done in a commercially reasonable way. We're going to enter kind of the land of pretend and pretend that this was the actual purchase price. And so we're just going to give the plaintiff seller the difference between what he should have been able to sell these for and what the original purchase price was. So because of that, the seller, as you can see, has an incentive to really get this be a reasonable price. Okay, so let's flip on over and look at these statutes just for a second. So we're going to look at, we'll start with 703, the withhold delivery of items. Here we go, getting in the neighborhood at least. So 703, seller's remedies in general. So this is the actual Texas statute. You can see here, this was passed in 1967. That's when we adopted the UCC, at least Article 2 of the UCC. So this is the language that we've been focusing on. Where the buyer wrongfully rejects or revokes acceptance of goods or fails to make a payment due on or before delivery or repudiates with respect to a whole or the part, then with respect to any goods directly affected, and if the breach is of the whole contract, then also with respect to the whole undelivered balance, the degree party may withhold delivery of such goods. You can see withhold delivery of such goods. Withhold delivery of the goods. Exactly the same concept here. One thing I want to flag here, we don't do a lot of this in this particular course, but this is the way statutes are written, and you can see that there's lots of commas, lots of clauses, lots of layers of meaning, and many times you'll have a sentence that is kind of freakishly long. I mean, look, this is all one sentence. It's not going to win any stylistic prize because it's very, very loaded down. Nobody sits down and reads a statute starting with word A and going to word Z and immediately understands all of the elements of it. It really does require kind of sitting and taking it apart and considering one clause and then another and then adding those two clauses together. It's difficult to do. And so in most of our classes in this program, we kind of unpack it for you. We kind of try to do the analysis, almost like how a secondary source unpacks a primary source. But it's also a good idea sometimes for you to kind of spend some time with the statute, because at the end of the day, you will be reading statutes and you will be trying to make sense of them. So this is an example of one of those that you might be struggling with, tussling with, so to speak. Let's consider this one. Another thing that a successful seller might be suing for, or actually not suing for, but taking this action, is to put an insolvent buyer on a COD, cash on delivery basis. Let's look at that one here. Move up a little higher for this one. Let's see, where, here we go, this one right here. Where the seller discovers the buyer to be insolvent, he may refuse delivery except for cash, including payment for all goods theretofore delivered under the contract, and to stop delivery under the chapter. So that's the cash on delivery situation. Stop goods in transit if they are in possession of a third-party carrier. Let's look at that one. We're going to scroll down to 705. Here we have seller's stoppage of delivery in transit or otherwise. Hopefully you're getting the sense that our UCC version is very, very similar to the version that we see in our textbook. Really, the language is, in most cases, going to be identical in those two. Let's consider this last one. Resell the goods in a commercially reasonable manner and then sue for the loss. So that's 706. I'm going to scroll down for this one a little bit farther. Yes. Under the conditions stated above on seller's remedies, the seller may resell the goods concerned or the undelivered balance thereof. Where the resale is made in good faith and in a commercially reasonable manner, The seller may recover the difference between the resale price and the contract price together with any incidental damages allowed under the provisions of this chapter, but less expenses saved in the consequence of the buyer's breach. So that's going to that commercially reasonable manner language. So what I'm trying to show you is these are just, these snippets are almost as long as the actual language in the statute. We also have sue for damages, and the way we calculate the damages are we consider the original contract price, what the a seller was expecting to get, then the price that he actually got, which is usually going to be less because, again, you're selling them in a kind of a rushed manner under less than ideal circumstances. So this subtraction problem is likely to be a positive number, plus any incidental damages that the seller had to bear, maybe advertising costs associated with letting the marketplace know that he or she is selling these items, and then any consequential damages that perhaps result from the breach that the defendant had. Another thing that the plaintiff can do is cancel the contract and then sue for the breach, and also reclaim the goods that were delivered to the insolvent buyer after making a timely demand. It's another provision of that. And we can see this language right here. 703. Cancel the contract, resell, and recover damages. And we have about the seller's damages for non-acceptance or repudiation. So all of this is our version of the UCC is basically the version that we're looking at in the text. Now we're going to consider the buyer's remedies. The most common of the buyer's remedies is to sue for damages. So again, we have the market price at breach less the contract price. So I mean, before we do this, let's consider the buyer circumstances. How have we ended up in a breach situation? Well, probably the seller has not been able to or willing to provide the goods that the buyer has contracted for. In that situation, let's say that the buyer has agreed to pay $10,000 for a particular item or items, and he's waiting to get the delivery of those items and they haven't arrived. So now the buyer's in a pickle. He needs the stuff, so he needs to go out and look in the marketplace for these items. And as he looks around, he discovers that if he wants similar items right now, he's going to have to pay $12,000. So that will be the difference here. So this amount is going to be more than this amount. And in this case, the difference is $2,000. And then again, there's going to be incidental damages. It's going to involve the buyer doing some research, and that involves man hours or woman hours for that matter. And then there could also be consequential damages. And we have this topic covered in 711. We also have, and of course related to this is the idea of cover, which we have here at 712. And this is the idea that it's not just a matter of figuring out what this price is. Probably what the buyer is going to do is actually buy here. It may be that he's decided he doesn't need the items after all, and so he's just trying to figure out, well, what is he out because he wasn't able to get the items for $10,000. But more likely, he's going to have to buy them from somewhere else. And if he actually goes out and buys it, we call that cover. What is cover? It's a remedy under the UCC which allows a buyer, if the seller has breached a contract of sale, to purchase the items elsewhere. This is what we call the cover. I think of it as an umbrella, that this is the protection that the buyer is doing. The buyer is seeking protection from this alternative seller that's keeping him dry, so to speak, keeping him out of harm's way, keeping him out of a bad situation. And he's going to hold the seller liable for the difference between the cost that he should have paid, this one, and the price that he actually did have to pay. Now, of course, it's always possible that the price of the item has actually dropped and the buyer is able to buy the item not for the $10,000 that he initially contracted for, but maybe he's able to buy it for $9,000. So he's actually it's fortunate for him that there was a breach, but that's not the usual situation. Now, this cover idea is very similar, as you probably noticed, to the idea of the sue for damages as calculated situation. It's more accurately resell. Actually, sorry, I'm sorry. This is the one that we want to look at. Reselling the items for a commercially reasonable price and then suing for the loss. The duty of mitigation fits here too. So if I'm seeking cover, I can't go out and buy the most expensive item ever. I mean, there's 4 different companies out there that I go to, and one wants to sell me the item for $20,000, and another one wants to sell it to me for $15,000. Another one wants to sell it to me for $13,000. They're all fungible, essentially the same goods. But I find it eventually for $12,000, and that's, of course, the one I'm going to go with. If I happen to have picked this one, let's say I'm too lazy to do a lot of research, or maybe I just like this particular business, and so I want to reward them. So I'm thinking, hey, the buyer's ultimately going to have to pay the difference, so what do I care about shopping for a deal? But again, that duty to mitigate is why I ought to care, because if the defendant, in this case the seller, can find a deal where I would have been able to buy this for $12,000, then that is what I'm going to be held to. Even if I spent $20 and my difference there is $10, if the evidence is presented that I could have bought it for $12, then my damages would be capped at the 2,000 points. So that's my motivation to look for options. I'm not going to go through this. This is a very detailed examination of the buyer's remedies. I'm only really expecting you to know these buyer's remedies. So this is kind of nice to know. If you want to do a deeper dive, feel free to do so, but I'm not going to hold you responsible for the information on this particular slide. So in this scenario, we are Anne. We happen to run a catering business, and this is our usual setup for that fancy wedding or dinner. We have very elegant place settings, elegant china, elegant tablecloths, and other assorted silverware, other assorted things. But we've entered into a contract with a particular client, and this client has somewhat unusual taste. This client wants a yellow theme for his or her. We'll say it's a wedding, and we'll say that we're dealing with the bride-to-be. She wants the yellow color. So she wants the tablecloth not to be this off-white or this creamy color. She wants it all to be yellow. And so she's having to look around because it's supposed to be a bright yellow. So she's having some trouble finding a tablecloth that seems appropriate for a wedding, but that is a very vibrant yellow color. And she needs to perform the contract in 21 days, so she's in a fairly tight frame of reference. So what she does is she goes to an online company and she contracts to buy these tablecloths. She agrees, in fact, to pay $600 for that, and this company says that they will be able to deliver it in 10 days. So that gives her 11 days of play here, 21 minus 10 is 11. So, and she recognizes, well, if something falls apart, I still have the ability to maybe recover it. But unfortunately, the delivery doesn't happen. And in fact, after 19 days, they still haven't been able to deliver the tablecloths. And so Anne runs down to, Bed Bath & Beyond, or who knows where she goes to, and she's able to miraculously find enough of these yellow tablecloths to meet her needs. But unfortunately, at the Bed Bath & Beyond, it's going to cost $800, not the $200. So here we have this equation. This is the same equation that we have right here. The market price as of the day of breach, which is going to be that $800, the original contract price, which is $600. So we have those two numbers. Now we're going to look at incidental and consequential damages. In this case, we only have incidental damages, which is $20 it took Anne to drive around town looking for the appropriate tablecloths at the brick and mortar stores. And so we have $200 here plus $20, so $220 is her damages. So again, think yellow here. That's our deal on the tablecloth. Okay, now let's go on and talk about some equitable remedies that might be available to the buyer. Usually we don't see equitable remedies relevant to the seller. That's usually more of a buyer thing because the seller is interested in cash. I mean, that's what most sellers want. They don't want you to, when they are giving you stuff, the buyer stuff, they don't want you to give them stuff back. They want, currency. They want money. And money is a legal thing. Money is not an equitable thing. So sellers rarely are going to need or want equitable remedies, but buyers sometimes do, although even usually there, the legal remedy is what is sought. So there are two that we're going to talk about. They are specific performance and Replevin. Both of these are very similar to the same thing. So I'm not going to focus on distinguishing specific performance from Replevin, because they're usually synonyms for each other. But let me just define what these terms are, because these terms are used elsewhere in the law, and especially specific performance. Let's just do a refresher, though, before we dive into these particular equitable remedies, and do a little refresher about what equitable means. So equity is, you could say in our system of law, there are two types of law, so to speak. We have law and we have equity. And the characteristics of them are not the same. We used to have two separate court systems in common law jurisdictions. If you wanted equity, you would go to the chancery court. If you wanted law, you'd go to the court at law. If you, and so the plaintiff had to make a choice. The plaintiff couldn't get both. He had to figure out which one was the best deal for him. And so in a chancery court, the judge would be interested in applying equitable principles. The court would not be focusing on awarding money, but would instead be focusing upon issuing some type of court order. It might be requiring the other guy to give up some stuff, like that unique Claude Monet painting, for example. Or it could be an order telling somebody to stop doing something or to start doing something, like an injunction, something like that. So if that's the type of solution that the plaintiff wants to his problem, then it's better to be in a court at equity or to seek an equitable remedy. Court at law is going to be focused on money. Most of the time, that's what plaintiffs want. They want money. If a contract has been breached, they don't want stuff usually. They don't want a court order. They want cash. And so usually the legal remedy is going to be what the plaintiff wants and actually what the court prefers to issue. Now, in Texas and in most jurisdictions, the two legal systems have been combined into one. And so now the plaintiff doesn't have to pick. The plaintiff doesn't have to say, I am choosing equity or I'm choosing law. He or she gets to choose to sue for both. So this is not an either or, it's an and situation. One of the things about equitable remedies are that courts are usually somewhat reluctant to grant them. They really are only going to grant them when the legal remedy is just inadequate under the circumstances of the case. So the inclination, the strong preference of the court is to award a legal remedy. But again, in those rare circumstances, equitable remedies can be appropriate. So let's consider the two that we're focusing on today. The first is specific performance, and this is the rock star of the two of these. This is the one that you see mentioned much more in the legal literature. This is the equitable remedy of compelling performance of a contract where damages are an inadequate remedy. So for example, let's say that I am the seller, and I'm the only seller of this particular item for hundreds of miles. And you have ordered them from me, and you really need them like right now. And you've ordered them in this particular shade of blue, we'll say. And you're just not able to find them anywhere else for that shade of blue. I have them in my inventory, but I really want to sell them to somebody else because I think I can get a better price, frankly, than you and I negotiated. And so you could seek an order from the court saying, hey, Groover has this stuff, just make her give them to me according to the terms of the contract. And the court might say, okay, we're going to do that. But usually the goods are going to have to be unique or very hard to find, because otherwise the court's going to say, listen, I'll just give you money and then you can go out and buy them somewhere else. Why do you need to hassle Groover? Different performance. She can make the business decision about whether she wants to actually meet the terms of the contract or pay you off. So this is not really a replacement for legal damages or for money unless there's something kind of unusual going on in the situation. Now let's consider Replevin. This is also an equitable remedy through which the owner of personal property taken or detained by another may recover possession of it. So let's imagine this transaction that you happen to have, well, let's use the wedding example. You have, you want to marry in your mother's wedding dress, but it needed to be some repair work. It needed to be altered and cleaned, and so you gave it to a seamstress to make these alterations. But she's been backlogged and she hasn't been able to make the changes. Well, guess what? Your wedding's in just a few days. You need the dress, but she's not willing to surrender it to you. Well, this would be a case where you could get Replevin. Oftentimes in these situations, the item actually isn't being produced by the seller. The seller is just maybe performing a service or making some change to the item. So you can see in the specific performance, usually the item is actually being manufactured by the seller. So there's a subtle difference between the two, but for the most part, they're very similar concepts. And again, this can be a situation where a cover is an inadequate remedy because after all, the wedding dress, I don't want just any wedding dress. I want the one my mom walked down the aisle in. And the only way that I can walk down the aisle in that dress is if I get that particular dress back from the seamstress. Here's a few other remedies. A resale of goods after notifying the seller of the buyer's rejection due to their nonconformity. So let's say that I want you, or I order a green tablecloths and you deliver blue tablecloths. I don't want blue tablecloths. I let you know, hey, come and get them. And you say, no, I'm not going to. I'm not going to refund you your money either. And so under those circumstances, the goods are clearly non-conforming. I've clearly told you I reject them. And so under those circumstances, I can go ahead and sell them. I'm going to have to do it in a commercially reasonable manner and time. And then I can, I'm probably not going to be able to sell them for the same price that I ended up having to pay for them. That difference is what I would be suing you for. Another option the seller has would be canceling the contract. And we saw that back when we were back in the buyer arena. Cancel the contract and then sue. So we have that same option here. And then revocation of acceptance. Maybe there's a latent defect in the item. We accepted initially, we're the buyer, we accepted initially because we thought the items conformed, but after a closer inspection or the use of it, we recognize, no, these really don't conform. And so that can be revocation of acceptance when the acceptance, the initial acceptance was a reasonable action, is similar to rejection, initial rejection for nonconformity. Another thing that you can do sometimes is you might retain, if you're the buyer, you might retain the non-conforming items and request a price adjustment. I really wanted green tablecloths, but I can work with blue tablecloths. It's less than ideal. I'm going to want a deal on them though because I'd really prefer green, and so that would be something that I could negotiate with the seller. What we've been talking about at this point has been what the UCC establishes as the default rule, as how we're going to solve these problems when the contract itself does not specify what should happen. But the UCC actually does say, here, I can. Here. So it's in 701. Remedies for breach of collateral contracts not impaired. Remedies for breach for any obligations or promises collateral ancillary to a contract for sale are not impaired by the provisions of this chapter. So the parties can contract for other solutions if they want to. The UCC fills in the blanks if the parties haven't contracted otherwise. But the parties can contract otherwise, and those terms will usually be enforceable. For example, the parties might contract for liquidated damages, which specify exactly how much the damages will be if there's a breach. This adds a lot of certainty to the transaction. So if you go back and look at these examples, the parties didn't really, go back to this example, the parties didn't really know how expensive it was going to be for Anne to find those yellow tablecloths at the Bed Bath & Beyond. Maybe Bed Bath & Beyond didn't have any, and she's going to have to travel, you know, to Oklahoma to find them, or maybe she won't be able to find them at all, and her contract is going to be breached. So there's a lot of uncertainty about this whole thing. When you have uncertainty, it creates fact issues, and it makes it more likely that there's going to be litigation. On the other hand, if the contract specified that if the internet tablecloth company doesn't provide the document, the things, the tablecloths, I'm sorry, that it's going to be a $300 fee. It might be that Ann's actual damages are greater than $300. Well, too bad for Ann. Or it might be that Ann's actual damages are less than $300. Well, then that's too bad for the internet company. But it's established beforehand. That way, everybody knows what the rules are. There's really no need to have a lawsuit, because Ann can just say, hey, look at paragraph 417. That tells you you need to pay me $300. So just pay me $300. Now, consequential damages provisions need to be reasonable. Nobody has a crystal ball, so they're not going to be sure exactly what the magical number would have been if they hadn't had the liquid damages clause. But we can see here with Ann's situation, $300 is probably pretty reasonable, because after all, her damages actually ended up being $220. Now, if the liquidated damages clause had been $3,000, especially since the price of the item was only $600, probably not too reasonable. If it were $3, that probably also wouldn't be reasonable. So you're looking for something that's in the ballpark, but the courts are usually going to say, hey, you know what, a reasonable number they're going to assume is going to be enforceable. Let's discuss the topic of anticipatory repudiation, or anticipatory breach is another term for this. We called it anticipatory breach earlier, more commonly. Sometimes what happens is, going back to the example that we had here with this tablecloth company, let's consider this. Let's say the tablecloth company had called in and said, listen, you know, our inventory record showed that we had enough of those yellow tablecloths, but once we sent somebody into the warehouse to find them, they recognized that what we had entered into inventory as yellow tablecloths were actually green tablecloths. We don't have any yellow tablecloths, and we can't source them in time for your needs, so we are going to breach. Now, in this situation, the initial contract gave the company, Dining Solutions, 10 days to provide the tablecloths. But it's on the 5th day that Dining Solutions figures out they can't meet contract. At this point, they're not in breach. They are going to be in breach for 5 more days. So they don't have any obligation to do anything with respect to Ann. But they decide to let Ann know. Why did they do that? Well, there's a couple of reasons. One is customer service. Letting Ann know as early as possible is going to make Ann less likely to be angry at Dining Solutions, less likely to post some internet thing about how awful Dining Solution is, more likely for Ann to consider using them in the future, since they, were very honest with her and gave her the time to go ahead and find alternative arrangements. So that's the customer service aspect, but there's also a legal reason why Dining Solutions may well want to anticipatorily repudiate the contract. And that is that this gives Ann more time to mitigate, more time to seek cover. The more time Ann has to seek cover, the more likely she is to seek cover at a good price. If she's having to do this the day before, the price here is going to be significantly higher because she's going to have less time to be able to shop. And so under these circumstances, if she knows, a lot sooner, well, she may just be able to go to Amazon, and maybe she ends up paying, instead of $600, $620, a relatively small upcharge. Well, under that situation, Dining Solutions has a much significantly reduced exposure to breach of contract. And so it actually helps Dining Solutions from a litigation management perspective to anticipatorily repudiate. But there is a risk associated with this, because let's say Dining Solutions lets Ann know that they don't have the tablecloths and they're not going to be able to satisfy her order. And then the very next day, they discover, oh, yes, we found the yellow tablecloths. If they had only waited one more day, they would have been able to find the tablecloths and then get them in the mail to Anne. They would have arrived by the 10th calendar day, and there would have been no breach. And so by telling Anne about by anticipatorily repudiating, they've created a customer service issue they didn't need to, and they have created some litigation risk for them that they didn't have. So now that Dining Solutions on the 6th day have discovered that they have they found the tablecloths, then it is in their interest to go ahead and let Anne know. But it's possible Anne has already ordered the items from Amazon, or maybe she's gone down to Bed Bath & Beyond and gotten the tablecloths. After all, Dining Solutions didn't make it sound like there was any possibility they would find it, so Anne did the responsible thing to mitigate this cover. And so if Anne has gone ahead and taken them at their word and sought other plans, other arrangements, then the fact that Dining Solutions has the yellow tablecloths doesn't mean that somehow or another Anne needs to buy their tablecloths anymore. So Dining Solutions, the repudiator, is out of luck once they want to retract the repudiation. But let's say Dining Solutions catches Anne before she's actually placed an Amazon order. I mean, she's run some numbers, she's checked some things out, but she hasn't actually pulled the trigger and ordered from Amazon. And, so she's still thinking about which way she's going to go. Is she going to go with Amazon or some other business? So Dining Solutions calls her up and says, hey, we found the tablecloths. We want to withdraw our anticipatory repudiation. Anne's like, yay, great, this is awesome. And so Dining Solutions and Anne agree that there is no need for Anne to mitigate. Dining Solutions mails those yellow tablecloths to Anne, and they arrive within the 10 calendar days. Everybody is happy. That's a wonderful solution problem. So let's consider here. In our scenario, the non-repudiating party, in this case Anne, has some options. Let's go back in time when Dining Solutions initially called Anne to let her know about the anticipatory repudiation. At that time, she could wait for the performance. She could say, I'm still going to wait until the 10th day. Because, in an anticipatory repudiation situation, sometimes it does work out. The stronger the anticipatory repudiation, the less reasonable it is to go ahead and wait for performance. But that is an option. I mean, the contract hasn't been breached at this point. Another thing that Anne could do is resort to any remedy for the breach of the contract. And in this case, she's seeking cover, and she's going to sue for difference. Another option would be to suspend her own performance under the contract. And certainly under this situation, it's reasonable for her to not pay for the things she's not going to get. In this case, Anne is not, it's the seller who's repudiating, not the buyer. So there's no need to salvage or identify. So the repudiating party, Dining Solutions in this case, can retract its repudiation before the performance is due. And it has the effect of reinstating the contract. But if Dining Solutions said, hey, we're sure we're repudiating, then Anne can reasonably go ahead and seek the mitigation, seek the cover. And so it's no longer in the hands of Dining Solutions once the repudiation is final. That doesn't mean that the Dining Solutions can't contact Anne and work something out, but it's now kind of under control. So when Dining Solutions retracts its repudiation, let's assume that Anne says, okay, I'm interested in exploring this possibility. Anne might demand some kind of assurances. She might say, well, take a picture of these yellow tablecloths. My order calls for 10. I want to see these 10 sacks of tablecloth that are yellow spread out, and you take me a picture and you email it to me. That would be an example of the type of assurance that might be appropriate. And so that would be one way that Dining Solutions would be able to demonstrate that it is going to be able to satisfy the terms of the contract. Because naturally, Anne would be a little suspicious at that point. Okay, so let's move on from Anticipatory repudiation and talked about the doctrine of impracticability. We talked about this in the common law section. Sometimes things happen. Hurricane comes in. Doesn't make sense for me to expect you to mow my lawn when there's a hurricane coming through. When my factory burns to the ground, it doesn't make a lot of sense for you to expect me to provide widgets for you, even if possibly maybe I can make arrangements to use someone else's factory. And so when one is given notice that the seller is not going to be able to perform due to impracticability, and that notice is seasonably given, and what this means is given in a reasonable time frame, then the buyer does have the option to terminate the contract or to modify the contract. For example, I might be saying, let's say I'm the seller, I might be saying to the buyer, listen, we had an electrical problem in our factory, so we're not going to be able to provide your widgets by the due date, but we think we can get it to you a week later. Well, the buyer might say, okay, that's okay with us. So we'll modify the contract to change the due date. Or the buyer might say, no, we need them the day we need them, and so we're going to cancel them. Let's talk statute of limitations. The usual statute of limitations for the UCC is 4 years. So if a UCC contract has a breach, then whoever is a non-breaching party wants to sue, he or she has to sue within 4 years. This is the fill-in-the-blank UCC answer to this. But the parties do have the opportunity in the contract to change the 4-year statutory period. And usually when they do, they make it closer, sooner. And they can make it as short as 1 year. They can't make it shorter than 1 year. They can make it as short as 1 year. So if the parties choose to, in their contract, restrict the statute of limitations to 1 year or 2 years or 23 months or whatever they want to do, as long as it's at least a year, they're okay under the UCC. 4 years is the default. It has to be at least as much as 1 year. So at this point, we have completed Chapter 15. If you have any questions about the material, please don't hesitate to reach out to me. My email is cgroover@collin.edu. I look forward to hearing from you. If you have questions and email doesn't seem to be the best way of getting those resolved, please feel free to come to my office hours. I love to talk to students about contracts, and I would be delighted to just talk to you face-to-face or virtually or by telephone. I look forward to hearing from you soon. I hope this presentation has been helpful for you. If you have any questions, again, reach out to me. Thanks so much for your attention, and have a wonderful day.